WFLA Now will begin momentarily. WFLA Now will begin momentarily. Live from WFLA Studios, top stories, breaking news, interactive coverage in the palm of your hand. This is Stream Center Live. Here's JV Buno.
Key hearings plus a scheduling conference that could set a start date for the Idaho murder trial. That is, if the indictment handed down against Bryan Kohberger has the legal footing to survive dismissal attempts. We're going to have a panel of guests, an interactive Q&A, and the 4 o'clock hearing itself all ahead from the Stream Center. Hello and welcome back to the Stream Center, folks. JB here with you live across several platforms. We'll be live on all platforms momentarily. Back talking about Idaho, back talking about the legal case in front of Bryan C. Kohberger. Hearings that will be happening today. Actually, one hearing that is currently ongoing as we speak. I'd like to bring in from Idaho, right outside the courthouse, News Nation national correspondent Alex Capriello is joining us there live. Alex, it's good to have you on stream for the first time. Alex, what do we know about these two hearings today? Starting with the first one that, as I understand it, is going on right there behind you.
Yeah, exactly. This is the Latah County Courthouse where all of the pretrial hearings for Bryan Kohberger has happened. He's actually in a jail that's below this courthouse. He comes up each time for those pretrial hearings. Most of the time he's wearing a suit and tie, but he is very present in each of these pretrial hearings that I've been to, listening closely. Today there are two separate hearings that are happening. The first one is completely secret, private, off limits to the public, and also reporters just like me who fly to Idaho to cover this type of thing. Really, they're talking about the grand jury indictment that happened last year, right? This is what sets the standard that says that there is enough evidence to move forward into a trial phase. What they are discussing today is the defense's motion that they believe that there was not enough evidence to lead to an indictment, that the grand jury members were possibly biased, and also that they were using the wrong burden of proof in order to reach that indictment. This is something the defense has actually been actively working on for several months now. A previous motion was already denied by the judge back in December. She said, no, you're wrong. We feel like there is enough evidence here to move forward with a trial, and we believe that they were not biased. But still, the defense is pushing. They say that we believe we have new evidence that we need to bring forward for you to reconsider your decision. And so that's what's happening right now behind closed doors. JB, after that, at 1 p.m. local time, they're going to have an open hearing that I'll be able to sit on. This is also about the grand jury indictment, but it's more procedural, and that allows someone like me to actually sit in and listen to that. Now, to the final point, something that you hinted at, it is entirely possible that we have an actual trial date scheduled today. At the end of the second hearing, there's going to be a scheduling conference. The attorneys for both sides, as well as the judge, will look at all the remaining pretrial hearings that they probably want to get in the books. Also, what day and what time they want to actually get this trial going. We don't know for sure, but everything that we're hearing, JB, is that we can expect most likely a trial to begin some point this summer after the University of Idaho and the public schools here in Moscow, Idaho have wrapped up for the summer.
I think a lot of people who are tuning in right now, Alex, are very curious to see or learn when a trial could be expected to begin. I want to talk about, we're going to answer some questions from folks. We also have Emily Baker, who's going to be joining us a little bit later on the stream, again being joined by News Nation national correspondent Alex Capriello from the courthouse in Latah County, Idaho. I want to talk about that first hearing real quick, Alex, the one that's ongoing right now. If I understand this correctly, and please correct me if I am wrong, this is Bryan Kohberger's attempt to, through his legal team, to basically get this dismissed on the grounds of inadmissible evidence or lack of sufficient evidence, any misconduct that might have occurred, but that they're also, if I'm understanding this correct, they also want that to be unsealed, right? So if their case and really the ammo that they have behind today's first hearing, if the judge were to grant that to be unsealed, do we have any idea as to when we might learn more about what Kohberger's getting at with this motion today?
Yeah, typically what we've seen in the past with these pretrial hearings is that John Judge, that's his name, John Judge, actually doesn't really make decisions right away off the bat. Usually he takes time after a pretrial hearing to think about both sides' arguments, to weigh it in his head, sleep on it, and then he issues a written ruling later on. Sometimes it takes days, sometimes it takes weeks, and eventually it's filed to the website that we can all see. So we are hoping to get some sort of clarity about what actually is the decision here, but let's talk a little bit about what it is that the defense is trying to do. You mentioned the belief that the defense has that there was inadmissible evidence or potential bias, potential jury tampering. That was already denied. The judge denied that motion back in December, right before Christmas. This is a second chance to try to do that because during that process, the defense got more information about what evidence that they looked at, the grand jury looked at, and perhaps they have some sort of new argument that they can make in front of the judge. And that's why they're asking for that judge to reconsider that decision, that December decision that said, no, the grand jury process was fine and well, and we need to move forward. So they're asking the judge, rethink it, please. We have a new argument, and they're making that argument currently right now during this first hearing. And then, if the judge, again, denies that motion and says we need to carry on, well, then the defense is asking, well, then we want our argument about why we believe this grand jury indictment should be thrown out, made public. And that's a big deal because everything surrounding this defendant and this upcoming trial is under a very strict gag order. There's very little information that comes out about what both sides are arguing, what the evidence is. And so the defense is saying, look, if you're not going to dismiss this grand jury indictment or dismiss this case altogether, then we want our arguments made public because the people have a right to know exactly why we believe it should be dropped.
Right, of course. I mean, we have seen so much put forth at this point, going back to the arrest affidavit. We know a little bit of what is stacked up against Bryan Kohberger, but as far as what his defense is going to look like and how that's taking shape and what exactly he has to prove his innocence, I mean, we're still on the outside. It feels like we're on the outside looking in. And transparency, so much a theme in this case, but interestingly enough, Alex, as you know, you're about to go into that courthouse there behind you. This second hearing is not only open to the public, but a bit of a change now. We're going from the pool camera feed that, was basically organized by the media at large, and now we have John Judge, as you noted earlier on, who is going to be streaming this on his YouTube channel, which is a very 2024 kind of thing that we're now pivoting from a pool camera to his own YouTube page, really. And we're going to be monitoring. In fact, I'll show everybody live. We'll hit the touchscreen here. We're not getting this from some secret avenue, folks. We're getting this all from the same exact place, and that is his YouTube page. But Alex, do we have any idea what this is going to look like and how long this is expected to be? Really, what do we expect for this second hearing?
Yeah, I think you're right, JB. It could set the standard for court hearings from here on out, particularly if this is a success, if maybe more people are able to pay attention than they could have before when they had to wait maybe for a pool camera to feed it back to their network of choice. But regardless, it is going to come from Judge John Judge's YouTube page. It sounds strange and a little wacky, but that's how it's going to go. And we're expecting at 1 p.m., hopefully it goes smoothly. What I do know and what I can tell you, while I haven't seen sort of the layout that we might expect today, what I have seen in the past is from pretrial hearings, because the live stream has existed for up to this point for the victims' families who weren't able to actually travel here to Moscow to see sort of the legal process play out in these pretrial hearings. So the 4 victims' families have always had access to a court live stream. Now, for the first time today, it's going to be public for everyone to see. And typically what I've seen in the past, at least 2 different camera angles. The first one is a wide shot that shows the entire courtroom from a distance, of course. The camera's located on or near the judge's or the jury's bench. But you should be able to see the prosecution's table, you should be able to see the defense table, you should be able to see the defendant, Bryan Kohberger, although it will be somewhat distant. And if my memory serves me right, JB, I'm pretty sure there's a single camera that's always trained on the judge as well, since the judge will likely do a lot of talking as well. So you want to make sure that's crystal clear for people to hear. So I think that's what we can expect when that YouTube live stream goes live in about 45 minutes from now. But that's really all I can tell you because we just haven't seen it. It's unprecedented for us as well. And then on top of that, I'll just quickly add new rules for the court as well in terms of live tweeting. Typically, a lot of true crime followers like to follow these really important trials through X, or formerly known as Twitter. Reporters now can't be doing that. They can't even really send emails as the new court orders. We can only really take notes, and that's about it. And once the court is broken for recess, then you can start to fill your viewers in, or even fill in your network about what was happening behind those closed doors.
Which is a shame for me because, Alex, I love to follow when you live tweet court cases. So we do not get that here today, unfortunately. Alex, I want to get you out on this. Actually, before I move on to the next point, I want to follow up on a point that you made. Because we were talking about this off stream for a second when we first got your signal up, how we cannot. It would be very easy for me in the Stream Center to digitally enhance this image and be able to do a digital zoom in on Bryan Kohberger, but you are basically saying that based on the judge's order, that any digital alterations, anything that basically makes it more of a focus on the defendant in this case is prohibited, and so we can't do it. We're basically just sharing the actual feed itself, correct?
Yeah, that's right. I think in the court order, the words are manipulation of the live stream. The judge doesn't want people that watch this live stream or repost the live stream to zoom in on Bryan Kohberger, because that was the whole reason that we don't have pool cameras in the first place anymore, is because the pool cameras were zooming in and focusing, in the judge's opinion, too much on Bryan Kohberger's face, on his hands, on his behavior. And now, I would argue that that's very important things for people to see. I mean, it's the full picture. If you can't be in the courtroom, people want to see that. And looking and viewing the defendant, how he's behaving, how he's watching is important. But it crossed the line in the judge's opinion, and so that's what led us to where we are today. No more pool cameras. And so, yes, that is a part of the court order. The judge does not want you to zoom in on Bryan Kohberger if you're going to repost this live stream. How that goes in terms of enforcement, I'm not sure how the court can enforce that all the way across the world, but that's at least his ruling.
And I'll get you out on this. One thing that our last live stream on this topic, on Bryan Kohberger, on Moscow, Idaho, we were talking about the demolition of the home where the murders occurred, the crime scene itself being demolished after the University of Idaho spurred the demolition to take place really over the holiday break. We live streamed the demolition here. I still hear from people about that. In fact, I had someone come up to me last week expressing confusion over why that happened before a trial took place. Your boots on the ground in Idaho, have you heard people still talking about that? Is there any relief in the air that the house is no longer standing? Are there people that are upset? Have you heard anything specifically about that?
Yeah, I mean, I think it depends on who you ask. I mean, we know firsthand that several of the victims' family members wanted that house to stay up until the trial happened. The argument being, who knows if a jury might have wanted to walk through, see the angles of the house, the stairway, the bedrooms. Now they can no longer do that. The house doesn't exist. When you talk to people here in Moscow, that's downtown, like I was doing for the past 2 days, I asked about that, how they felt about the demolition. And I think the answer I got most often was that most people are kind of happy. It really was sort of this sinister place that was, scary. That they knew what happened there. University of Idaho students have to walk by it on their way to class. And so I think it sort of feels like a relief to many people. So again, depends on who you ask. I know that there's arguments for both sides. I think overall the feeling that I get from the people of Moscow is they just want this behind them. They want a trial date to be set today. They want a trial to happen on time, and they want to move forward from Bryan Kohberger and this horrible tragedy that's happened.
If you want pictures from of course King Road there in Moscow, Idaho, Alex Capriello has it on his Twitter. I still call it Twitter, Alex. Habits die hard in this industry. Too. Yeah, it's hard, man. Alex, we really appreciate your time. Appreciate you, of course, braving the cold out there. Good luck. I'll be following you, of course, across social to see what you learn over the course of the day. Thank you so much for joining us.
Thanks for having me, JB.
All right, Alex Capriello. Give him a follow, folks, on social, and really appreciate his time. Again, I'm going to be glued to his socials over the course of the day. I'm looking here at our comment section, and I see a lot of purple hearts, and that can only mean one thing. That means that the loyal following of Emily Baker has found their way into the live stream. And Emily, our special guest on this live stream, joins us now. Emily, it is so great to be back with you on stream. I cannot wait to hear you help me figure a lot of this out, because you are my legal expert on today's stream. And I was watching you when I was out on paternity leave, making sense of this case and what was next. So first and foremost, good afternoon. How are you, my friend?
I'm doing really well. Court is doing what court does in January. November gets slow. Like from Halloween to the New Year, court gets really slow. And then every case in the world gets crammed in between the New Year and like spring break. And that's how it was when I was doing trials in Los Angeles. And it's what we're seeing now, that courts are so busy right now. And Idaho's been real frustrating because everything feels like it's sealed lately. And it's been difficult to glean information about what's going on in this case that so many are invested in.
We're going to start to take your questions, folks, with hashtag Hey Emily, hashtag Hey JB in the comments section. I just can't help but smile because I just love Emily's content so much. Anything, you guys, that can make the complicated issues more easy for us non-lawyers to understand. That's why it's so great that we have Emily on stream. But let's just start with that. Emily, here I am watching a Netflix documentary, over the holiday break, and there you are popping up, of course, and talking about Johnny Depp and Amber Heard, and that really being a bit of a pivotal moment when it came to court transparency, right? I don't think that we've ever seen that level of access with multi-camera setups, being able to see, every eyebrow movement from Johnny Depp or every look. Eye movement from Amber Heard. And here we are now with this case. Now, of course, we're talking about criminal versus civil, very, very different. But we can't help but feel like we're on the outside looking in a lot of respects. What do you make of the transparency or lack thereof, if you will, with this case thus far? Is it on par with you? Does it stand out to you? What do you make of it?
We're in a really different time when it comes to court access, court transparency, and social media. And I think a lot of judges watched the Johnny Depp and Amber Heard case and what happened around social media, for better and for worse. And I think some judges are nervous about it. We saw conspiracy theories popping up on Twitter about Amber Heard blowing her nose on the stand, or was she doing something else? And judges are very mindful of that and don't want it happening in their courts. And Idaho courts have been particularly guarded when it comes to court access. And when the court, Judge said multiple times, we don't want the cameras zooming in on Bryan Kohberger. And then Bryan Kohberger's attorneys are filing motions saying, but they're still zooming in. And I think we're going to see court coverage more like C-SPAN, where it's a zoomed out view of the court. You can see both parties sitting at counsel table, but we don't have multi-camera angles zooming in on people. And we really saw Utah tackle this in the Gwyneth Paltrow case. They had a very strict court order on cameras focusing on just the speaker and the judge when the judge is talking, not just on Gwyneth Paltrow or the plaintiff. And it worked really well in that case. I wonder if we're going to see more courts say we're set up for Zoom court. We've got cameras. We'll just control it ourselves and stream it ourselves so there aren't errors. We saw errors in the Young Thug trial where jurors accidentally got shown on screen as a camera was panning. So when the court takes control of that, it reduces error, but it also can feel like the court is trying to control what the public sees too much. And that's really the push and pull we've seen in motions since the beginning of this case, truly.
As we look here at the case, and that's not Alex actually bring up Emily. I want to look at this. He's got 15,000, if I'm not mistaken, 15,000 subscribers. I mean, Emily, how soon until he starts selling merch? I'm actually really genuinely curious, because if Judge John Judge wants to, retire from a day on the, being a judge and then, start to do his YouTube channel, guess what? He's already got a head start.
Well, I think the 15,000 are people waiting for the hearings on this, because in all the motions they put out, they said they're going to put it on this channel and people want to get those notifications. So they're definitely subscribed. It's interesting to me. I caught this courtroom live a couple nights ago when I'm on YouTube a lot, shockingly. When I was on YouTube, they were doing like a test live stream and there were only a handful of people there, but they had a pretty good angle of the counsel tables and an angle of the judge. And I think that's what we'll see today. It was an empty courtroom, but they were trying out the stream. So I imagine the stream will go live right before court starts. And there was just a hearing in the Rust case yesterday for Hannah Gutierrez Reed, and the court did the same thing. It was a hearing over Microsoft Teams. They streamed it onto the court's own YouTube channel, and that's how the public could access it. And I think we're going to see more of that.
You know me, I've talked about it on stream before. I think you and I have talked about it. I try to be a champion for transparency and things being able to be accessible in some respect, one way or the other, unless it's, of course, if it's a closed court hearing or closed trial for whatever reason. Understand that, but if you can't be there in person, you can be there virtually. Technology affords us that. I'm not going to go into my big lecture, my big spiel.
You and I are on the same page with that. I think it's a really good thing. And in a case like this, it's impacted two large university communities who were affected by this case. So even when you look at the local community, there's not enough space in this courtroom for everyone impacted by this case to attend court. And for that reason alone, it should be made accessible to the public. But I think cameras in courtrooms are a good thing. I think all cameras should have courtrooms. I'm frustrated that federal courts don't allow it. And I think people would feel more comfortable with our legal system if they saw more regularly what's going on and stopped feeling like the court system was somehow hiding something from them.
We're going to get to your questions coming up here. You can use #HeyEmily, #HeyJB. We're going to do that. The Q&A is going to start in about 3 minutes time. Let's just get some of the easy ones out of the way. Dismissal, Emily, the chances of that remote, correct? Or no, am I wrong?
Very, very remote, especially based on a historic motion, based on whether or not the standard of proof is right or wrong for a grand jury. That's the standard of proof. It's not beyond a reasonable doubt. It's always been probable cause for grand juries and for preliminary hearings. They're fighting an uphill battle on that, but it seems that the defense attorneys in Idaho have been regularly fighting that battle across different courtrooms. I don't think anything's going to change. I think it'll end up going to the state Supreme Court and getting more final and settled law on it. But Judge Judge wrote a very good and thorough opinion. I think he enjoyed the legal jesting on that topic, but a very thorough opinion that this is not going to fly. And the state Supreme Court has addressed this similarly, and it's not going to fly. But whether or not they get the ability to pause this trial and appeal it is kind of their next big thing. Will they get that interlocutory appeal that pauses the criminal proceeding and kicks this case to the appeals court, which could push this trial out a year or more?
I want to point out, too, I should have done this off the top. Emily, I believe you're live streaming this as well, correct?
I'm going to cover the hearing with live commentary. So for all of those that want commentary while the hearing's going on, I'll be doing that. For all of you who just want to see the hearing, I'm sure you guys will be airing it here on WFLA.
No, yeah, and I appreciate it. But Emily, folks, does a phenomenal job providing commentary in a non-invasive way, in my opinion. So if you're just looking for the feed and you just want to watch the feed, but if you're also looking for that legal context, look, I'm not shy. Emily, of course, is going to be streaming it as well, and that's That's just fantastic. I want to bring up this one point here about this hearing that's ongoing right now. We just had Alex Capriello joining us from outside the courthouse there, Emily. And one of the things that of course sticks out to me about that first hearing is the attempt to unseal the motion. Is that an attempt to score any points in the court of public opinion? It's almost as if Kohberger's side wants there to be something that is known about something that they perceive to be out of procedure or out of protocol, no?
It's so strange to me to see the prosecution fighting for it to remain sealed and then objecting to the motion to seal and then putting the objections under seal. It's been a wild procedural process. But yes, the defense wants their arguments made public, and the prosecution's arguing that it deals with grand jury. It is my suspicion, and this is a suspicion, that there was or could have been live witness testimony at the grand jury, that they might be trying to protect that testimony or the processes and procedures of the grand jury. The defense is saying that these motions don't go into that, and the prosecution is saying that they do. And Judge is really trying to balance what's sealed and what's public and put out an order saying, I have found that there was no prosecutorial misconduct, no bias, no improper evidence. So even though it's sealed, he put out an order not addressing the nature of the arguments, but addressing his findings, saying these things do not exist here. But it's interesting seeing the defense really trying to bring more to light, because with the judge's non-dissemination orders, they can't really speak to the media. They can't comment on anything other than court documents, and they're not getting their side really out to the public in any way because everything's sealed.
And then this second hearing, which of course we are going to be following here live, myself, of course, about the previous refusal to dismiss the indictment for inaccurate instructions to the grand jury. I'm looking at all of this. Are these Hail Mary attempts to just get this thrown out, or is this a tactic to buy time?
I think the defense has been thorough and strategic in bringing every motion they could possibly be. When we get to the end of this trial, there's not going to be an argument that the defense attorneys should have brought another motion. I think they are doing their job as capital defense attorneys. This is still a capital case until we hear otherwise. So yes, it could partly be buying more time, but also I think they're going through every single motion they could bring to zealously represent their client, even though some of them are very much long shots. And this is one of them. The improper instruction is based on that standard of proof, and I don't think they're going to get the appeal on the standard of proof. I think it's settled law, but you never know what John Judge will do. He might say, go ahead and take the appeal, because one of the things trial judges very much try to do is make sure that they don't get this case to a jury, have the jury deliberate, go through weeks of trial, bring, the surviving roommates in, put the victim's family through all of that, and have the defendant go up on appeal and have a conviction overturned. So sometimes they are more cautious early on to allow the defense much more leeway so that the case is more tight when it comes to appeal, a little bit more bulletproof on that.
If everything goes according to plan today and we are expected to proceed towards trial, Emily, the scheduling conference, I think, is going to be something that people really pay attention to, because we could get a start date before.
I hope so.
I think everyone, I think universally public, you, me, everybody just wants to know when this is actually going to begin, right? Especially the family members of the four victims who are curious as to what justice is going to look like for them. They have been in so much pain. They have been tormented, of course, by this entire process and by all the uncertainty that has surrounded it as well. And they just want to know when they are going to have anything close to closure, something that resembles closure for them. And so one thing I want to ask you, though, and then we'll get to the Q&A, I promise, right after this. We're going to start to take your questions so you can file them in now, folks. But one thing I want to ask you is that if you're Bryan Kohberger, you're probably wise enough to understand that more than likely this is something that the judge is not going to want to do this while class is in session at the University of Idaho. He's probably going to try to make this happen at a time that works with the entire community, given the high profile magnitude of this case. If you're Bryan Kohberger, do you want this happening this summer? Or are you thinking, you know what, if this got delayed to summer 2025, that's okay by me. I can wait a year and lock up here underneath the courthouse. What's your sense of that?
I don't know what his defense attorneys are working on. So if his defense attorneys feel like there is still a lot of things to overturn, they just got some of the DNA discovery. If they feel that there is a tremendous amount of forensic discovery that they still need to go through, and this case had terabytes, like 50 terabytes of data for the defense attorneys to go through. More time is going to be helpful for them. And since Bryan Kohberger waived speedy trial, there's no real time frame. Yes, we are a year out from when these crimes occurred, but murder trials regularly take multiple years. And this is a 4-victim murder trial with a complex scene and a lot of digital forensics. So I'm not surprised that the defense would want to push this out if they do seek to push it out. I think we've seen so many trials that have gone very quickly. Murdaugh comes to mind. Darrell Brooks comes to mind. Those defendants didn't waive speedy trial, and it was within the year that the thing happened. But that is very much the unusual case when it comes particularly to homicide cases. These things normally take several years to get to trial. So I wouldn't be surprised.
Yeah, you have to wonder what Kohberger just sitting there in lockup, what kind of also mental state that he is in, and what that experience has done to him mentally, if he is in a rush to get to trial, or if he's willing to wait. We really have no idea. The only thing that people can do is truly speculate. I want to get to the questions as we noted, and I want to point out our system has since been upgraded. We can now, and actually it's prioritized. If you put in hashtag HeyJB or Emily on Twitter/X, that actually appears now at the front of my panel on this screen in the Stream Center. So Twitter shows up first, followed by YouTube, and then Facebook. Let's get to Marie's question. Hashtags for us both. Hey, JB. Hashtag Hey, Emily. Do you think that the international attention this case has affects the court's ruling on allowing camera access? Does it add pressure on the court? Interesting that she's asking about international attention because she is watching from Ireland, Emily.
Hey, Marie, I think that the court is much more focused on the local community and access for the local community, because that's going to be John Judge's first concern. And this is the community likely where he lives as well. This is a small community. So I think the local attention is more, but I know that the judges are aware of the international attention. We've seen him put that in rulings as well, saying that he wants to be mindful of how much attention there is on this case, and balance that with the defendant's right to a fair trial. So I think the first consideration is local, and then it goes broader.
How about this one? I thought of this one, Emily. Judgmental. Maybe you can, because you saw the live stream pop up from Judge's page. Hashtag KJB, if Judge John Judge, I could mess that up probably 50 times today, leaves chat on his live stream, could that be an issue when it comes to trial regarding jury bias? Is there going to be chat on his page?
Judge Mental must have been watching the Taking Care of Maya trial, where there were accusations after the trial that a juror had gone into live stream chats and talked about this and identified themselves as a juror, and it came up to a whole bunch of hearings. I hope that the court is savvy enough to turn off chat. It could be a problem. I see a lot of problems with leaving an unmoderated chat just wild on the internet. And I think that the judge and his court staff will be mindful of that. And if they're not, they will learn very quickly that they need to be mindful of that. I'd be surprised if chat was turned on.
You almost get the sense, right, that this is almost a bit of like a trial run today. Pun not intended, by the way, on me calling it a trial run. But
it is a trial run.
It is a trial run. Now, clearly, to see how this goes today. Emily, I know you're curious just like I am. Karen's asking, do you think Bryan Kohberger will ever get an unbiased jury? We get this question all the time. What's your take on it?
They found an unbiased jury in the Johnny Depp Amber Heard case. They found one in the Murdaugh case. Well, I guess we'll see what happens with the Murdaugh case next week. But they found juries that aren't paying attention to the media, aren't paying attention to social media and are living their lives. I think because this is a small community, it could be a challenge, but they will expand the jury pool to go from a wider jury pool. And unbiased doesn't mean jurors that have never heard of this. It means that jurors that are like, oh, I heard something about that, but I didn't really pay attention. You're not going to get jurors that are like, I am the biggest true crime fan. I've listened to every podcast in the world. But those are individuals that are not going to sit on most criminal juries. So we've seen high profile cases in Idaho find impartial juries, and I think they will find one here. I know for those of us that love following this stuff on the internet, it seems weird that other people don't, but other people really don't follow this as closely as we do.
It's true. I still run into people and I talk about some of the biggest court cases and they have no idea what I'm talking about. It's not for everybody. I promised that Twitter/X was the first one to pop up on my screen, and here it is. Hashtags for us both. Why do we think that they want things unsealed? And also, are you covering the Delphi case? I'll just really quickly on that. We cover things that people ask us to cover. We very much listen to our audience about interactive live streaming. So if you send an email to heyjb@wfla.com and request coverage, and we get enough emails, of course, we'll cover anything that you want us to cover and put here on the live stream. But Emily, to the point, why do you think that they want things unsealed? Do you think that there's something big looming in this case, the elephant in the room that we just don't know about yet?
I wonder if the defense wants to feel like the playing field is more leveled and their side of the story is out there a bit more. The prosecution's theory of the case has been out there for quite a while, but if we're getting glimpses of the defense's theory of the case through these motions, that's not getting out there to the public. Again, it's very odd to me that the prosecution is like, nope, keep it sealed. But it was weird to me that everybody involved in this case was like, hey, let's not have cameras in the courtroom. The prosecution didn't want them. The defense didn't want them. The judge didn't really want them. And the media coalition made motions fighting to keep access to this courtroom. And I know lots of people give the media a hard time, but the media coalition hired an attorney to fight for access and transparency in this case and has done that in other cases. And I think that that's a good thing, that most individuals wouldn't have the ability to go into court and argue really for all of us to have access.
Oopsie Daisy wants to know, hashtags for us both, what do you think the likelihood is that they change the trial location from being in Moscow?
I don't think they will do that immediately. When they start jury selection, and if they cannot find jurors, they will generally expand the jury pool and bring in people from a further radius. However, those people will still need to be in Idaho. They can't bounce over the border to Washington and bring Washington residents into an Idaho state case. That's not going to happen, but they can expand the pool. The last result is moving venue to a larger metropolitan area, which generally judges are hesitant to do, but will do as a last resort. But they will wait until they start selecting a jury before they make that decision.
Sarah says, please cover the Harmony Montgomery case. That's one that we hope to be doing more live streams about in the future. Let's go to this next one from Melissa. Hashtags for us both. At this stage, are they just going through the normal motions, or do you think that there's any tactics/gameplay/spice has begun on either side? Sending love from Nottingham. Oh, Emily's a lawyer. She knows better than most about the tactics and gameplay, if you will, that goes on. The spice, Emily, you know about the spice.
I love the spice. I love spicy court, and John Judge does too. Judge likes to question these attorneys. He likes to have kind of the intellectual sparring back and forth on the motions. But no, this is a capital case. I think that though some of the motions have been a bit of a reach, I don't think anything's reached outside of zealous advocacy. The defense is pulling on every thread they can to defend this case. And it's the kind of a defense I think anyone who had a family member in this situation would want for that family member. You would want a defense team that's looking at every single angle and has the time and ability to do so. No one's going to get to the end of this case and say that Bryan Kohberger did not have excellent and zealous representation. The ceiling of everything is where I think there's some strategy, but we don't know what the strategy is yet because we don't know exactly what's sealed, and I hate it.
Right. Again, Emily and I are both very much on the same side of the equation when it comes to wanting to learn more about what we're talking about here on both sides. Look, on both sides, we want to learn exactly what the prosecution has, what the defense has. It just makes us more educated in our ability to do our jobs. Steve wants to know, will he face trial for all 4 murders at the same time? That one we can absolutely say yes, of course. But is it possible he could be convicted of only some of the murders, is the question here from Steve.
When there are separate charges, it is always possible that somebody could be convicted on one charge and not the others. Based on my time as a prosecutor, it is very unlikely that they would find that he is guilty of one of the victims and not the others, because this isn't homicides in different locations. This seems to be a contiguous event, all happening at the same time, all happening in the same location. So it would be very unusual and very strange indeed to see a jury split those victims up. So I would think that it would be very unlikely that he would only be convicted as to some of the victims. We would need a lot more info on that.
Still looking here at Judge John Judge, his YouTube page.
Still no stream.
Nothing yet. Nothing yet. Emily, do you anticipate that he would go live early just to, let people, like a streamer would, hey, we're here. Like to let people know, like, hey, this is where you find us. Or is he going to go live right at the moment that he shows up in court?
They may still be at lunch, given that they had a morning hearing and this is on local time. This is the first time we're seeing this court stream, so they might not make that live until the second court is called to order. So that would probably be a little off of the 1 o'clock hour, instead of showing a video feed of the seal or something the way that a in-camera pool camera would do. So I think we'll probably see him go live the second that court is being called to order, and not letting the public have access to the lawyers milling about in court before the hearing starts.
Yeah, very curious to see exactly when this begins. We've got a team, just hitting the refresh button. I don't know who it is.
Same.
Someone's hitting the refresh button to make sure that we have this. And Emily, we're going to get you out here in about 3 minutes. This is a last call for questions for Emily, because she's got to go start her own stream. And for folks that want Emily's very fun legal perspective and also extremely intelligent legal perspective, please, of course, you can absolutely watch the live stream on her page as well. Or you can, the people are asking me, Emily, saying like, hey, I want to watch it from the source. Yeah, it's youtube.com/judge or @JudgeJohnJudge is the YouTube handle. So people have been asking. This is interesting. Julie is asking this question, and we'll come back here on camera. #Emily, or excuse me, #Hey Emily. Does Judge need permission to stream publicly?
No, he doesn't. He gets to grant the permission. So he's the one that gets to decide what he does. And then he would follow local court rules as to whether or not the court streams to YouTube. I imagine they have local court rules about turning off monetization and things like that. But we've seen other Idaho courts do this. I imagine, and again, this is just from A, working with judges, B, being a prosecutor, and C, now having friends that have taken the bench. I imagine he has talked to the other Idaho judges that have had high-profile cases about how this worked for them in their courthouse and how it worked for them online. And he's taking notes from those cases where we've seen other judges do this in other Idaho cases. So I imagine he is well prepared for it. His court staff has talked to those court staffs about how it works, and they've shared that information. But he's the one that gets to grant the permission.
Emily, we're going to go. Familia, we got your question coming up. It's right there on screen. We won't forget about you. But really quickly, Emily, I just want to ask you, if you're Judge, you are very cognizant of the fact that this is a high-profile national/international case. Does that change how much of his normal behavior and normal patterns and normal decision-making process as a judge get influenced by the fact that this is commanding so much attention?
One would hope not much.
Right.
You would hope that you just get a slice of regular court, and the same way you would if it was of intense local interest, even not international interest. But I imagine Judge is choosing to do things a bit more methodically, knowing that it is going to be streamed and discussed. How could you not? And so I don't know if it's this judge's normal practice to not rule from the bench. He waits and does written motions, but they're very thorough written orders. And get the sense that that is his normal practice, that he is thoughtful, he takes things under submission, and then puts out a written order sometime later. And I don't think that's changed because of the streaming. But of course, they're cognizant of it because courts have to deal with all of the intense floods of emails that the
Yeah.
courts get about the case. They have to deal with other attorneys like myself talking about the case. They have people in their lives that are watching this coverage being like, I saw you on TV today. It's a very different thing. Most of the judges and lawyers that I know would never wish that their normal court workday be on a stream like this. It is not comfortable for anyone involved, and most attorneys don't become attorneys to be on TV. A few do, but most don't.
But at the same time, can't help but wonder if when the case when our legal system is under the microscope with a case like this, as much as it is, if it almost serves as a litmus test for the mainstream public to say and ask themselves, does our justice system work? Like, is this what we're doing here in the United States? Is this working? Are we actually doing this thing called justice correctly? And so I always wonder about the mindset of judges when it comes to whether it's Murdoch or whether it's Petito or whether it's this particular case. Familia Christie wants to know, do you think that this is a case that will go cold due to huge media coverage? Do you think that outside influence could slow things? I think is what Familia is asking here, Emily.
Familia, normally I associate cold with being unsolved. So
Right, me too.
I don't think there's going to be, any meddling in that way until we get to trial, and then we're going to see the things we've seen in other high profile cases with people on Reddit saying that they're jurors when they're not actually jurors and that sort of things. But I don't think it's going to be unsolved. The prosecution considers this case to be solved and prosecutable. I don't think the media attention changes that. I think what cases like this do is help the public understand how our system works, which is slowly, sometimes methodically, and sometimes in a very frustrating manner. The victims' families have to be tremendously frustrated with how much is under seal because they don't know what's going on either. And feeling like you're on the outside in a case involving your child, I don't know if there's much that could be worse than that. So this is frustrating for the public, but also for those involved immediately in this case. And it's why we've seen victims get attorneys. But no, I don't think it's going to go cold. I think it's going to be slow.
One more question from me and one more from William here, and that's it for the Q&A. William wants to know, is there evidence that you think that we don't know about yet?
William, I love this question. I don't normally give percentages when I talk about law, but I'm going to give you one today. 100% there's a lot we don't know in this case.
And
Absolutely 100%.
how did you know that I was going to ask you in this next question for a percentage? Did you, I don't know if you read my mind or not, but
I absolutely read your mind. It's hard with law to give percentages, but again, I was a prosecutor for over 10 years. There's so much that we do not know about this case. We know the scantest amount of information from really the probable cause affidavit and the arguments over DNA. That's all we know in this case. There is so much outstanding, and the trial on this case is going to be very interesting because of how little is known. Other high profile trials like Murdaugh, we had more information. In a Darrell Brooks case, we had most of the information. Even in a Johnny Depp Amber Heard, most of the depositions and things had been made public due to the prior trial in the UK. This is a case where we're going to tune into trial and not know what's happening, what the witnesses are going to say, and how they piece this case together. And we're all going to watch as jurors because there's not much information to be had.
And speaking, the question I was going to ask you for a percentage on, I'll just ask it. You don't have to give me a percentage if you don't want to, Emily, but percentage chance that this actually does in fact happen this summer. The trial, that is.
I don't know what else the defense needs. I don't think it's terrible odds that they set a trial date in the summer, but whether that actually goes or not will be different. I think summer is probably a good option for them because the university will be on break. It won't be as disruptive to the community. So I would give it a 50-50 shot that it goes to trial in the summer. I don't know how busy Judge's calendar is and how much time they're setting aside for this trial. If this is going to be a 6 or 8 week trial, they really have to plan pretty carefully for that amount of time to be in trial.
Emily Baker, folks, the one, the only. I think it's obvious when people watch us together that I'm such a fan of yours, just because of how much I've watched your content across multiple platforms. So, all the best to you. I got to make my way up your way soon so that we can get together and meet. I'll give you a big hug.
JP, I'm such a huge fan of yours as well. I love what WFLA has done here, and I, like so many, tuned in to all of your live streams with the Petito case. You guys had such ethical and excellent coverage of that case, and the Stream Center made it so interactive in a way that not many outlets are doing, and you really have changed the access of people to news, and I think brought people back to the news in a way that they want to engage with. And I have just a tremendous amount of respect for what you're doing, and I'm so glad that you're doing it.
The respect is overwhelmingly mutual, Emily. And look, as I will be watching back your live stream as you're about to go live and talk about this case as it happens in real time. So I will be watching it in the future. All the best to you on the live stream, and I'll catch up with you soon, my friend.
We'll talk to you soon. Bye, JB.
All right, take care,
everybody.
Emily. Bye-bye. Big round of applause, everybody, for Emily. Yeah, just a pro's pro. All right, everybody. We are refreshing this now every 30 to 60 seconds, I've been told. And as of right now, I do not have a feed. We hope to have a feed here shortly. There was a question in the queue. I can continue to answer questions here in the meantime. And this one comes in from Coyote. We'll leave this up here. Coyote, off the subject, but many of us follow you on multiple cases. Please briefly update on Petito versus Laundrie. Yeah, quick update on Petito versus Laundrie. That is going to be happening in May, third week of May, if I remember correctly. And depositions continue. New paperwork has been filed specifically about the deposition process. As a reminder, Gabby Petito's parents suing the Laundries and their attorney, Stephen Bertolino, for intentional infliction of emotional distress, claiming that they didn't do enough when Gabby was missing, accusing them of knowing more than what was led on at the time. That case is still very, very much in happening in May, and so we will, of course, be streaming that. Any hearing and any, of course, any occurrences with that case will be streaming here. And you can follow me at WFLAJB across my socials, because that, even the smaller things, I will post updates on that from time to time. We wait here for Judge John Judge to go live. And I just want to make sure that, that we are still refreshing this, right? Because make sure that this is 100%. We don't have a cookie and staring at just a blank screen, if you will. It's weird looking up a judge's YouTube page, but that's what that is the massive shift now in this case. And no, nothing is live yet. We are still waiting for him to actually click on the live button. You know what's interesting about this too is that there's no activity on this account, which basically means that when after the live stream is over, the video is no longer there. So as far as archival purposes and people being able to, what if you can't watch it live? What if you're somebody who works Pacific time zone especially, and you can't watch it until afterwards? It sounds as if, and it appears as if, it might be a situation where it's one time. It's streamed out live, and then poof, it's gone. But that's why, again, us being able to distribute it, it'll look, if it's live streamed anywhere, it's going to live on the internet somewhere. It'll live on WFLA's pages. It'll live on elsewhere as well, but still no live stream just yet. Let's go back to some of the comments that are coming in. The only comments that I see here in the Stream Center are if you use hashtag HeyJB. That's literally the only thing that that pops up here. Kita Lou, hashtag HeyJB. Will there be an interview with the suspected killer? We've heard every other point of view but his. It wouldn't be an interview. It would be testimony. And that would be, of course, absolutely massive in this case, no? If Bryan Kohberger took the stand. Now, as a reminder, when when he was given the opportunity to enter a plea in this case. He did not enter a plea. It was a plea of not guilty that was entered on his behalf. So he did not speak in that moment. So what his legal strategy is and whether or not that legal strategy includes him taking the stand, that, of course, remains to be seen. There is so much more surrounding this case that we do not know on both sides, really, but especially on the defense side, but so much that we do not know, as Emily said. You could hear even Emily being a lawyer and understanding how this game is played when it comes to a criminal case this high in profile. She understands the inner workings, but even she, having covered so many cases, expressing frustration as to how little we know at this point in the process. If a trial is to occur in 4 months from now, you would think that we would know more at this point. We don't. And that in and of itself is abnormal, an anomaly of in some respects. Again, as a reminder, if you're finding the live stream here, when the live stream actually begins, I do not provide commentary. That is not my role here. The Stream Center's purpose is to be able to provide feeds and a respectful place for you guys to chat amongst yourselves. We have our terrific team of moderators that are helping keep our comment section kind and respectful to all. I have no idea if Judge John Judge knows how to turn off the YouTube chat. But if he doesn't, it's I can assure you, being somebody who does a lot of live streaming, that it's going to become a zoo real fast. And but again, today very much a trial run because this is the first time the pool camera is not part of the equation, folks. The media is not providing you with that inside the courtroom coverage. This is all coming from the court, and we just here are then distributing that signal out across the internet through our appropriate channels, through our respective social media channels. If you want to go watch it on Judge's page, it's right there on your screen. You can go there and go right to the source, or you can get it from us, and you can engage in the chat as well. Also, should point out that after this is over, we'll be coming back here and talking about what we have learned, reacting to the potential of perhaps the scheduling conference setting a date if it does get to that point. We'll kind of put a bow on things and talk about what we learned, any surprises, twists, turns. But as of right now, we are still waiting on this to go live. How many people we live for? Okay, about 10,000. Let's see here. Lil Patty, hashtag AJB, if Alex Murdoch, AM, gets a new trial, are you going to stream it? If we, look, we do interactive coverage of trials, right? We try to bring you guys in. We try to also run polls as well. We try to make the live streaming experience very much one that includes you. So if you guys, it all depends on how much, how many requests that we get. I mean, I'm talking about everything from emails to heyjb@wfla.com. That's really the main way. Also as well, DMs. Like we pull it all together and we say, okay, this is what people want the most. This is what people really are focused on and interested in. We can't cover every trial, and also doing an entire trial is a massive undertaking for any news operation. It's every day. It's sometimes you go beyond the normal hours, if you will. So we have to be selective in which trials we cover, but enough people responding to something or emailing us. Look, we go by what you guys want. This is very much a channel for you. Interactive journalism is all about spotlighting you guys. It's not about our opinions. It's about your opinions and reacting to what you guys have to say. I'm really glad you asked this, True Crime Junkie, how long this hearing will last. I don't know. And I have no idea. I'm here East Coast now. The time is 4:03 Eastern. And I have no idea how long this is. I'm here for the long haul. Now, you would anticipate that they would not go beyond 5 o'clock Pacific. that would be, of course, 5, 6, 7, 8 o'clock Eastern time. But look, you have things to get through today. You got to make sure that these motions are handled procedurally. And so we've covered some pretrial motions that are expected to go on for hours that take 20 minutes, some that are expected to go on for 20 minutes and can take 6 hours. We have no clue. No idea. The scheduling conference, which is probably what you're here for, the scheduling conference is when they would actually set a trial date. That could be 5 minutes. That could be, all right, does this work for you? Okay, does this work for you? Looking at the prosecution and the defense. All right, is your calendar free at this time? All right, you're not on that cruise vacation that you're going to be taking, in June. Oh, okay, good, perfect. We'll schedule it for then. It's just a matter of figuring out a time. Yeah, no, Gypsy says after the hearing is a scheduling conference. Yes, we very well might get a trial start date. Now, look, a trial start date is never set in stone. It's not engraved in concrete. We see delays all the time. The most interesting thing about this is that there has been this overall feeling that the courts do not want this to be done at a time when class is in session at the University of Idaho, that ideally you would do it when there is it's a 6-week trial. So 6-week window, including jury selection. And the only 6 weeks that are somewhat inactive over the course of the school year is the summer. So if you don't get it in summer 2024, as in a few months from now, you're looking at the potential of this trial being pushed back to summer of 2025. People are going to be upset. People are, you would imagine that also the parents of the victims, the parents of Kaylee and Maddie and Ethan and Xana are going to be, upset. But this is what happens with criminal trials. Sometimes they get extended into not months long, but years long as far as the wait as to when it could begin. Any other questions? We're waiting on Judge John Judge to go live. Just refreshing, everybody. Justin is asking on Twitter /X, #KJB, what exactly is this hearing for today? We talked about that at the beginning with Alex Capriello, News Nation national correspondent. But in essence, the first hearing, which was behind closed doors, was about a motion to dismiss the indictment. And then the second one that we're going to be hearing at great length in probably a matter of minutes from now is to reconsider a previous denial of dismissing the indictment because of inaccurate instructions, inaccurate conduct, if you will, the allegation of inaccurate instructions being presented to the grand jury. And as I understand it, the way it's all about language, arguing that the grand jury actually should have been told. They're arguing that to find proof beyond a reasonable doubt, rather than the grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would in their judgment warrant a conviction by trial jury. It's tomato. You could argue it's tomatoes and tomatoes, but it all depends on how Judge John Judge sees it. If procedure was not followed, then he could reconsider the refusal to dismiss the indictment that was handed down by the grand jury to Bryan Kohberger. But this is all considered a massive long shot. This is all considered by every attorney that I've spoke to on the phone or chatted with via text. This is all considered to be an attempt to just to try everything that they can, making sure that they are crossing their T's, dotting their I's, so that every legal option is explored to get this trial thrown out before a trial and happens perhaps this summer. Hopefully that makes sense. Guys, if I'm ever talking in a different language, if I'm not ever making sense, like, you could tell me. I try to make this as easy to understand as possible, but even then I need sometimes a translator like Emily or Peter, the lawyer coming on here to help me figure out, because self-admittedly, legal jargon, sometimes we go so much into the weeds, I get lost and I can't figure out exactly what we're talking about anymore. Sometimes legal cases can get quite complex and so granular with some of the motions that are filed, and then secondary motions, and then appeals. Sometimes it can make your head spin, but that's why we have brilliant attorneys that are able to help us understand what's going on. The time is now 4:08 Eastern, 1:08 Pacific. No live stream yet from Judge John Judge. Now, you heard Emily say, this is very, very interesting. Emily said that this was there was an attempt earlier this week, I think she said earlier this week, to go live, and it worked. So it was like a test, if you will. Like, hey, does this work? And so, look, as someone who does streaming for a living, I can assure you that there's 1,000+ ways it can go wrong, from your RTMP signal, from your camera feed, not having any audio, to this firewalls coming into play. There's so many different things that can, or it's just as simple as, look, they're finishing up lunch after the previous hearing, and they're gonna just go live whenever they actually are ready to go live. But the time is now 4:10 Eastern, and nothing. Some kind comments in here. Thank you. I see the kind comments. I just don't put them up on screen too much, you guys, because this is very much about your opinions and questions, and not. But some of the people who are putting in some really nice things. Thank you. That means a lot to us. It means a lot to me. Thank you. All right. Chelsea says, "Hey, JB, refresh." Okay, we're Chelsea. We're refreshing. Chelsea, one of our great mods. We're refreshing. Is it there? There it is. Ta-da. Okay, here we go. Let's listen in live.
This is remote. Mr. Kohberger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here also remotely, Mr. Nye, and Ms. Beatty. So we're here. This is an open case. You probably know we had a closed hearing this morning, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court, website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. So I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
Your Honor, I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back, even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt. We could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, And during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logsdon? Why?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Nye said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this courtroom. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations, we have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up and lodged. And we would submit that that's going to be unnecessarily complicated if the trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Thompson. Taylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial. And the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those, or 500 hours of high definition video. and we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor. That is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the CAST report. The court had ordered that we receive the CAST report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So sure. I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you
that. This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time. so it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County, it's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Okay. Thank you, Mr. Thompson. So you're saying, looking at this realistically and the amount of information, evidence, non-evidence, that you might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I don't want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe in March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want a direct, certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time, because we don't want to do this twice. We don't want to do this 3 times, because no matter what happens, okay, if he's convicted, it's going to be appeal, and that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So, I'm sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay. Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
Live from the Stream Center, breaking news on WFLA Now. Here's JB Buno.
The Kohberger murder trial will not be dismissed based on today's hearings, but it also might not be happening anytime soon. Judge John Judge hearing arguments on a trial start date with potentially March 2025, May 2025 on the table, and an unexpected twist. Arguments heard on maybe the concept of a venue change out of Moscow, Idaho, out of Latah County. Not expected today in the slightest. Welcome back. into the Stream Center. So much to break down. I have so much notes. I don't know if I'm going to be able to get to it all on this live stream. Court is adjourned, allows us now the opportunity to break down what we have learned. Also an opportunity for us to answer as many questions interactively out of the comments section. You can use hashtag HJB to get my attention across social media platforms, Facebook, YouTube Live, Twitter/X. You can use that as well. You heard Ann Taylor for the defense making quite an argument for, and really not even just making the argument, but listing all the reasons as to why doing a trial this summer is just, in her words, impossible. And I was jotting down a lot of notes. There were others tweeting this as well. I know my friend Brian Enton was also tweeting this out quite a bit, so I'm going to read this. But all of the monumental amount of evidence in this case, 51 terabytes of data, 10% only of witnesses being interviewed so far from the defense. You could hear that the defense has been working on this, they say, every single day, trying to put together an appropriate legal defense. But I'll tell you, over the course of this entire argument that I am hearing, and over the course of John Judge's comments afterwards, as he is now expected to mull this decision as to whether or not he's going to allow this to be extended into 2025, I couldn't help but think about Murdaugh. Here we are with the Alex Murdaugh trial, the immense amount of resources, the exhausting amount of work that went into that case, and the potential of it happening all over again as a result of just a mistake. You can clearly hear, really from multiple parties involved in this hearing, that they want to do this one. You heard Judge say one time, want to do this one time. And we ran a poll on YouTube Live asking our audience as to whether or not they want to see this trial happen in summer 2024 or a later date such as summer 2025. More than 90% of respondents, of course, as you would expect, want this to happen sooner rather than later. Perhaps no one more than the families of Kaylee, Maddie, Ethan, and Xana. However, the last thing that anybody wants is a trial that happens prematurely and a trial that has to happen a second time, or a trial that's going to have so many holes prodded in it that an appeal is inevitable, or multiple or a litany of appeals are inevitable. So it's about getting it right. And with 51 terabytes of data, as somebody who is a bit of a tech nerd, 51 terabytes of data is massive. We've talked about it on stream in the past. It's hard for people that aren't technologically savvy to really fathom 51 terabytes of data. Now, how much of that data is really going to be pertinent to the case itself, to the point where it would be presented in a court of law, and how much of it would just be tossed out for being inconsequential, that we really don't know. We really don't know. But 51 terabytes of data to go through, to comb through what is needed for trial and what is not needed for trial, that's utterly massive. Now, you hear here that in the case that that there are doubts as to whether or not this could be actually done in 6 weeks, that there would be expert testimony that would require special areas of focus. They were talking about the massive media presence in this case. You heard the prosecution talk about how you can go anywhere, and people, if you talk about just the name Idaho right now, you just say Idaho, and it immediately just puts people into a frame of mind regarding Bryan Kohberger and regarding the 4 victims, Kaylee, Maddie, Ethan, and Xana. Pretty staggering to hear that that the defense has only interviewed 10% of witnesses, that there are more than 100 people left. And I'm trying to scroll here on my tablet. There we go. That over the course of this, the defense saying that we need to learn Bryan's life story, that it would go back 3 generations to really understand, and that perhaps, again, getting into the concept of familial DNA, and really DNA is probably going to be a very, very much a core focus in this case. To hear about this piece of video, did anybody catch this? I'm gonna look at my stream chat. Did you guys hear about this video? there's some video that Taylor referenced that, and she was referencing it in relation to an 11th discovery request, some piece of video that is potentially days long, and that was sort of fascinating, wasn't it not? It made my ears perk up. Okay, what video? What video are you talking about? There's apparently a certain piece of video that is important enough to be brought up in a scheduling conference. This has nothing to do really with particular pieces of evidence, but we're hearing about specifics about a video that the defense needs to examine more thoroughly before they feel comfortable going to trial. What is the video in question? Is it a law enforcement? I'm trying not to speculate. I'm trying to give an idea as to what that video could be. I mean, are we talking about a video from outside the residence? Are we talking about a video that was worn by a law enforcement officer? Are we talking about what video in particular are we talking about here? Is it a video that we are aware of that already exists? Is it a video that that we've seen already, such as the traffic stop with Bryan and his father on the way back to Pennsylvania? What that can't be days long of, a video. That was something that was relatively brief. But, and I'm just going to isolate this to just hashtag HeyJB comments. I was reading all of your comments, but now we're just going to try to, Boom Boom is asking, are we talking about Ring cameras here? But what piece of video was important enough for the defense to bring up in a scheduling conference and highlight that as reason enough for, or part of the reason rather, as to why this cannot happen in summer 2024. Now, over the course of this, all I can do is think about the families of the 4 victims and what their reaction might be. And you heard Judge being very cognizant of the families of the victims. They absolutely, of course, this is part of our pursuit of justice here. Whether Bryan Kohberger is found guilty or found to be innocent, the families of these 4 victims, of these lives that were taken way too soon, they are of paramount importance. All lives connected to this directly of paramount importance. So, we have covered this extensively enough to know that the Goncalves family is undoubtedly going to react to the concept of, now I get that there's a gag order. I understand that. But the idea of a 2025 trial, when we have now been at this for more than a year, it's been more than a year since we have been covering this. That's just but not surprising, because we've talked about it on stream previously. 2025 was always a possibility. They don't want to impact the high school. They don't want to impact the university. It brings a massive amount of attention to a small town. If I can guarantee you, I know them well enough, if I were to have Emily on or Peter on or any of News Nation's legal correspondents on, any attorney that has been following this case, they are going to tell you the start date is somewhat consequential in that, look, both sides just need to be ready. Okay? Before the bell goes ding, ding, both sides need to be ready for trial. And given the mountain of evidence, it's not surprising in the slightest to hear the defense argue for more time. However, the idea of a venue change, now that is interesting. And the fact that it was brought up in a scheduling conference, you heard Taylor mention that they have not yet had the opportunity to really proceed with the necessary paperwork to file for a motion of change of venue. But it sounds to me inevitable that they are going to pursue, if they're going to bring it up in a scheduling conference, they're not doing that lightly. Undoubtedly, they are going to pursue a change of venue. What effect does a change of venue have? Will a change of venue give the jury selection process an elevated chance to find an unbiased jury? Will moving it out of Latah County perhaps put less of a strain on the Moscow community, on the University of Idaho community? What are the ramifications? How much does it change the case? It's not entirely unexpected, but I will tell you, and I've been following the Twitter chatter, it's unexpected today in the scheduling conference. So you know that Kohberger and his defense are mulling the concept of a change of venue. And you would imagine that they are going to explore that opportunity. Who does that favor? Does that favor anybody? How much does that change things? Do we have less of a chance of a mistrial due to jury bias? Jury selection is so key in cases like this. Again, not a lawyer, but I know from covering enough cases like this and speaking to enough attorneys that jury selection is absolutely crucial. Let's get to some of the comments. I'm just going to start to bring in hashtag KJB comments. Everyone, your reaction to a potential change of venue, your reaction to this potentially going back to 2025, March, or even the summer of 2025. What does that mean? TG, hashtag KJB. Does change of venue change the judge? That's an excellent question, and I don't want to speak. I think I know the answer to this question, but I don't want to speak out of turn, and I will get an answer to this at some point. Michaela wants to know, what ways do you think that they will go about selecting a jury? The formal process of putting out a questionnaire and basically using the all of the questions that you would ask in a jury selection process to rule out. It's basically process of elimination. You are starting with a very large pool of people. Well, look, it's a relatively small county in Idaho. We got to call it what it is. It's a small county. Now, it's not small as some other counties in Idaho, but it's not the same as doing a jury selection in a major metropolitan area. So you start with a pool, and then you very gradually sort of eliminate people and you're trying to get down to a core number of jurors that are basically the most qualified and least biased to determine the fate of another human being, the legal outcome of this case. Sammy, does change of venue have effect on media coverage? Do certain venues allow more media than others and vice versa? Absolutely. Yeah. I want to agree with Enton. Enton put it out on Twitter. I want to agree with him. He was pleasantly surprised by the quality of the live stream. I think that we probably could have done, I don't think that we needed to have the two people on the bottom of the screen. They were just kind of staring into space. Well, not into space, into their screens, but did we need to see them over the entirety of the Zoom call? Probably not. But look, the audio quality was excellent. We didn't have any signal drops. Okay. And it was the front section of the courtroom, a wide shot. You were able to see Bryan Kohberger, even though he was probably at 20 by 60 pixels. You're not talking about a whole lot of real estate there, but that was what they wanted. The bottom line is that we were able to see the courtroom. We were able to hear the arguments. We were able to ascertain for ourselves as to whether or not we fall on this side of the argument or the other. So first off, let's just start with talking about the fact that that we actually had a legitimate courtroom feed to use for our intents and purposes. Now, if you move it to a change of venue, yes, all of that changes now. There's absolutely, you're talking about a different courtroom. You're talking about a different camera setup for better or for worse. You just don't know. Will it have an effect on the number of media, the volume of media, the amount of national and international attention? In my opinion, being a member of the media, absolutely not. No, it doesn't matter if we go to insert county name here, Idaho versus Latah County, Idaho. Doesn't matter. Media is going to make it. I've spoken to enough reporters that have made their way to Moscow to know, You can't just fly in there. You're usually flying into a neighboring airport, driving over. It's not going to make a difference whether they tell their GPS to go to Moscow or some other municipality. It's just not going to change anything. Alexia, will the trial be public on TV? Well, it'll be on live stream. TV is just kind of a format now, for the most part, for things to be summarized for you after it has happened. You'll see this on the news tonight if you watch TV. But live streamed trial coverage has kind of taken the place of televised trial coverage. A television station can choose to. I like the SpongeBob picture, by the way. I wasn't expecting SpongeBob on the stream today. It can absolutely be televised on broadcast, but it's just not with the way that live streaming is now an accepted form of media. No, not really. You'll probably see it here on live stream. Bailey says, #KJB, when will the judge make his decision on trial date? Now, I think, did he say a couple months? Did I overhear that, or did my earpiece deceive me on that? Help me out, mods. Or an audience, did you guys hear that? Was it a couple of months that he said, or did he kind of leave it more open-ended? But based on the pattern of decision-making thus far with Judge John Judge, you're probably looking at a decision closer to summer 2024. The fact that he's not making the decision today pretty much means that the chances of a trial this summer are significantly decreased, no? If he renders his decision, let's say April 1st, and he says, okay, no, I've actually decided we're doing the trial this summer, in 6 weeks, you're going to have the defense is going, their minds are going to melt because of the fact that they would have had several months to prepare rather than just 6 weeks. So chronologically now, when he makes his decision is significantly impactful. If he comes to a hasty decision and says, nope, I'm thinking about the victims, it's all about the victims for me, doing it this summer. Okay, well, then you have maybe potentially, 3-4 months to prepare. But you can't wait till April to start a May trial. It's just not going to happen. So Judge John Judge not coming to a decision today, and you could see him there. He was thinking about it, but he said, he ultimately said basically that he wasn't going to come to the determination today that he's going to need to basically sleep on it more than one night. Basically means that this appears to be getting punted to 2025. Also, we asked the big question at the beginning of the stream, right, with Emily. We asked, does Bryan Kohberger want a summer 2024 trial? Does he? No. The question was definitively answered today. Bryan Kohberger and his defense want no part of a 2024 trial. They are still combing through evidence. They are still very much as they claim to be, in the infancy of discovery. 10% of witnesses interviewed? Got a long way to go. And also, conducting interviews with witnesses is not that takes you don't just do that in a day. If you have more than 100 people to interview, if you did one every day, Sunday through Saturday, I mean, one every day, you're still talking 100 days from now. And then you would still need to put it all together and then strategize for trial. There's just, look, it's not for me to tell you that a trial isn't going to happen in 2024, but I'm going to tell you this. The odds of a trial happening in this summer just went down significantly. And you can't help but think about Kaylee, Maddie, Ethan, and Xana's families, because this is more of now a waiting game for them, as they will have to look every day that lives on with the lack of justice takes a toll on them. And we know this because we have interviewed other family members in other high profile cases that will tell you that they want answers. And we are, after today, potentially further from answers than we are closer to them. All right, back to questions and comments. Yeah, judge said 2 to 3 months. So look, summer looks to be a faint possibility now. Lisa, will the attorneys? Yeah, the attorneys will remain the same if there's a change of venue granted. Who presides over trial? That I'm not sure. That I don't want to speak out of turn. I think I know, but I'm not confident enough in my response to be able to tell you. Charlie, why is this taking so long? What about a fair and speedy trial? That, of course, was waived, and look, it would appear that prosecution wants to get on with this, of course, but it would sound as if that they are still going through quite a bit. What was it? 9,000 law enforcement tips. 9,000 law enforcement. No, those are national tips. No doubt that a massive amount of those are going to be just inconsequential, but. Cam, we talked about this at great length on the last live stream. #KJB was destroying the House pre-trial a good idea. Look, I've run polls on it. I've asked people about it. I've asked attorneys, regular people, even just walking down the street and talking to people about that case, about the demolition itself. Most people, not all, most people just don't see the logic in it in demolishing the house. Our polls reflect that. My real life interactions with people reflect that. However, you don't live in Moscow. You don't live on that street. You don't have to stare at it every day. So there are those in that community that have been going through their own frustrations and their own sense of pain. Now, you could argue that that is so secondary to the families in their pursuit of justice, but it has been repeatedly emphasized that demolishing the house will not have any legal consequence on the outcome of the case, that they have what they need. 3D scans, they've picked up everything. Everything has been accounted for. Do you trust that? That's up to the public to decide. But it has been repeatedly assured that it will not impact trial. Autumn, #KJB, were Bryan's family in the courtroom today? You know, that's an Alex Capriello question. I don't know who was there. And our vantage point was very limited, obviously, because it was at the front, and also the way the camera was positioned. We couldn't see who was really back there. It was just too low res of an image, but Twitter will answer that question for us. Let's also remind ourselves, this was a lengthy day. There was an extended first hearing this morning on the indictment, and so it's almost like watching the second half of something and of an event and not seeing the first half. You just don't know where we're picking off from. They even reference in some of the opening statements in this hearing today, it was referenced pretty heavily that they were coming off of the afternoon, or I should say rather for them, the morning session, the morning hearing. Someone in our comment section to ask about summer 2026. Emily said this could go on for years. She's not wrong. There's no guarantee this could happen in 2024. There's no guarantee that this happens in 2025. It's basically when procedurally we are at a place when both sides feel like, okay, I'm ready to prove my case and prosecute. And then the other side, I'm ready to establish an effective defense. I don't know if this is true, Joseph, saying it sounded like the prosecutor wanted to change a venue because it may be hard to find a trial jury to give up 6 weeks. Well, it might not be 6 weeks. It could be more than that. If there is this mountain of evidence. And they have to go through it in discovery. It could potentially be a smaller mountain, but still a mountain nonetheless, of evidence that has to be heard at trial, not to mention, as Taylor referenced, an exhaustive amount of expert testimony, probably related to DNA. Let's just cut to the chase here. The experts that we would bring in are probably, it's all pertaining to the sheath left behind at the scene, the DNA that points to the Kohberger family, but doesn't definitively establish an ID for Bryan Kohberger himself, or that's what we've been told pretty much at this point in the process. Probably because of DNA, Steve. Why did the defense say they'd have to go back 3 generations? Probably because of DNA, but also because the defense is going to try to. I don't want to. I'm trying, you guys, not to go down the speculative rabbit hole too much, but we've seen it a pattern so often when you're trying to establish a defense for a potential murder suspect. What normally happens is the defense is going to try to paint a picture as to somebody who, based on their history, their upbringing, their childhood, the way they treat people, that somebody who would, from the outside looking in, would be perceived to be incapable of committing such a horrific act. This is what happens in most trials. You are trying to build character, and then you call character witnesses to try to reassure or not even reassure, but create doubt with the jury that somebody with this level of character could commit such a horrific act. Yeah, Ina, or Enna, I'm sorry, excuse me. I am also trying to figure that out. Can we go to Twitter and see what people are saying there? Let's go to Twitter for a moment. For those of you who don't know, people were asking earlier. Alex was there on assignment. Brian Enton, not feeling too well, a little under the weather. So he did not make he's the correspondent and friend of the program, of course, who would normally make the trip to Moscow to cover a significant pretrial hearing such as this one. He's feeling under the weather. Brian, from me to you, if you're watching, don't know if you are, but if you are, hope you feel better, buddy. Really do. Hope you feel better. Ellie, I'm really appreciative that you remind us of this. Do you think cell tower records will be substantial enough to be used as evidence? Didn't his defense mention missing evidence on this? Look, the trip and the cell tower triangulation that was done to ping Bryan Kohberger, his activity, and also to the deactivation of his phone, there are going to be technological witnesses that are going to be brought in. Talk about the accuracy and the dependability of that evidence. So I keep talking about DNA. Yeah, DNA is probably the first thing that comes to mind when it comes to expert testimony. But you might have, a Verizon expert, an AT&T expert, talking cell towers in this case. Because if that's a big part of the prosecution's case, then you could very well hear about it. Jax is asking, do you think the defense will try to push it back further from summer 2025, closer to the time? I don't know if, but I find it very interesting that March was brought up. Why March? If we're going to wait multiple years for this trial, does waiting 2 more months make that much of a difference? If it's going to spare the Moscow community from having to deal with, an active semester, an active spring semester, and a trial, and of course, high school being in session, all running concurrently, I found March to be really random and odd. I understand judge his perspective that we got to get this going at some point. But you'd probably have a difficult time finding anyone who wouldn't say, hey, look, March, May, it's a 2-month difference, and you really heard from the state that they really very much do not want to do this in a way that is disruptive to Moscow life, to Latah County life, and to priorities, which is, look, a lot of education in that town, from the high school to the University of Idaho itself. So yeah, Chelsea, I agree. I thought of that too, but spring break is a week. It's a week. This could go on for 6 weeks. If you believe the defense, they anticipate something closer to 12 weeks to 15 weeks. I mean, look, that sounds a bit much. The idea that a trial could go on but we don't know the evidence. Going back to the lack of disclosed information in this case, the lack of transparency, the lack of knowing or the point of knowing so little at this stage in the game. We really don't know if 12 to 15 weeks of a trial window is outrageous. We don't. It could very well be a realistic outcome depending on how much evidence is truly presented. Danielle, why is it so important to have the trial when school isn't in session? Think about it from a parent's standpoint. When questions like this pop up, my mind is always going to the financial ramifications. Think about it from a parent's perspective. If you're considering sending your child to the University of Idaho as a freshman, potentially for 2024, 2025, do you want them going there with the massive media entourage that would descend on that town and it being the talk of the city? All of a sudden, it just becomes a distraction. Do you want to spend thousands and thousands of dollars, tens of thousands of dollars potentially, to send your child to a school where there would be this massive lingering distraction for potential, 2 to 3 month period, maybe 4-month period? If you're the University of Idaho, you don't want this to occur when class is in session. Absolutely not. You want to assure parents who are paying or footing the bill to send their kids to school. You want to be able to assure parents that this will not impact their child's education. That's my take on it. But clearly, it is a priority to not do this when school is in session, and that's a pretty logical reason as to why. You just don't want it to be a distraction for kids and to impact more lives than this already has impacted. You do it in the summer. Classes are far fewer. You don't have high school really in session. It's just more of a downtime and a better time to do it. Yeah, they were originally shooting for May 2024. That was the date that was put forth in court documentation, that May 2024, Team Brittany would be doing this, would be the target window. But, I mean, when you hear about the X, Y, and Z arguments from the defense as to why they say it would be impossible for them to be ready. Kohberger is sitting in a jail cell waiting for this to occur. Let's not forget that. He's just sitting in lockup. And he's basically saying, he's communicating to the world, I would rather sit in jail for another 18 months and be ready to clear my name than then be out potentially in just a few months if he were to be, exonerated, if his name were to be cleared, if he were to be found innocent, and have it be done this summer. A year is a long time to just stare at the same four walls. So it's a long time for him to sit in jail. It's a long time for these families to wait for justice. It's a long time. But then there's the X factor. The massive X factor that really comes above all of this today. And here's what it is. And we will take some more questions, but this is the final real point that I'm going to make before I just start to really go through as many questions as possible. The massive X factor, and this is what I want everyone to take away from this today, is that if you change venue, school is no longer truly an obstacle. If you move it out of such a educationally centric municipality like Moscow, if you move it to a less populated area that doesn't have any schools nearby, where it's just a little bit more manageable, school is out. You don't have to worry about it anymore. Now, look, media would still go to Moscow, interview students on the street. It would still be somewhat of a distraction, but at least it wouldn't be happening in that county. That's why the potential change of venue is so massive. It can have a ripple effect and change so much about this case. 2024, 2025, look, both sides are going to, you would hope, both sides are going to be able to present their arguments with confidence so that a jury can come to the right conclusion at the right date. 2024, 2025, March, May, whenever it's going to be. It would appear that we are proceeding towards trial. But where trial happens is significantly consequential and could change so much about the X's and O's of this case. All right, to the questions. I don't know, Jason. Jason going to Twitter now. If not Moscow, where do they have the trial? Boise? Idaho Falls? I'm going to bring up a map. I don't know. It's not something I really extensively researched before today, to tell you the truth, because it was so out of left field. But if I bring up Moscow here on Google Maps, and I'm checking this out, and I'm looking at some of the, the fact, don't forget, it's right on the Washington state line. Okay, so you move it. Where do you move it to? I don't even want, the more I think about it, the more it might be irresponsible to just start shouting out town names. I don't want to do that, but Jason did it for us. Boise, Idaho Falls. All right, so let's do it. Moscow, Idaho. Directions to Boise, Idaho. 5 hours and 31 minutes away. So that's a distance. That's probably unrealistic. That's a long way to travel. But yeah, I really don't know. Okay, so to Idaho Falls. I can't point these guys. I've never been a reporter in Idaho. I can't point these out on a map, but I can look it up for you. $8 hours. Is that right? 8.5 hours away by car. Going down I-90 through down to I-15. I mean, Jason, I don't know, man. Those are far away. That I don't really want to talk about too extensively because I don't know. Barrett asking a very interesting question. Is Bryan Kohberger smart or dumb? This has been something that has actually been talked about because of course, his his educational background? Is he average intelligence, above average intelligence, below average intelligence? I don't know. I really don't know. Never met the guy. Never really heard him speak outside of a few words. And the video on the traffic stop. I mean, we don't know. And even if you hear somebody speak, there are people out there that aren't great, verbal communicators, but are brilliant. There are people out there who have tremendous difficulty verbally communicating, but are of extremely high intelligence. And then you have people, that are smooth talkers who are just below average intelligence. So even if you hear him, you can't ascertain as to whether or not he's an intelligent person based on just talking with him. It's just not how it works. It's not how you determine if someone's intelligent or not. We're going to spend another few minutes here on stream. Lex Nottingham. What about McCall, Idaho? Okay, so now everyone's just shouting out random towns. Okay, let's look at that. McCall, Idaho. Where are you? The town in Idaho. Yeah, I know that, Google. I know. McCall, Idaho. Directions to here from Moscow. Three hours and 17 minutes. Man, Idaho's huge. It's just a massive state. Bigger than Florida? Feels like it. But then again, to get from one end, to get from Pensacola to Miami, plus our traffic conditions in Florida. Oh. By the way, you guys, this is we are now in the extended Q&A portion of our live stream. All questions are on the table. It can pertain to this case or any other case. I'm really, if it has hashtag HJB, I'm just going to just start plucking them out of the comment section. This is an intelligent comment. Eno says, hashtag HJB, why can't they hire more assistants to look over all that evidence so that we can get this trial going this year? Well, this is a great question. But a legal team, in talking to enough attorneys, it's all about trust. All about trust and intelligence. But really trust. And which assistants would you just pick up off the street to? And also, too, do you have the ability financially to hire more people? It's not as if these teams are sitting on a mountain of cash just ready to dole out dollars to attorneys or even any form of legal aids, even those in law school. Again, you can't just pick anybody. It sounds simple to, just hire more people to go through the 51 terabytes, right? Just hire more. I think it sounds simple, but it probably in reality it isn't. It's a fascinating question. How do you tell if someone is intelligent? I don't know. I mean, of course, there are IQ tests. There are standardized methodologies that exist for somebody to prove the level of their intelligence or lack thereof. But I truly don't believe that you can tell that somebody is an intelligent individual just by hearing them talk. Self-included. There are people, look, I'd like to think that I bring on stream people that are smarter than I am. I'd like to think that way. So that, or maybe not smarter in, I guess what I'm trying to say is I bring on people that can help us understand what we are covering. And some of the topics that we can get into are quite dense. So you bring on people that really can Let me put it to you this way. On some streams, I have brought on guests that are experts in their field, and their resume is impeccable and just filled with experience that is hard to quantify. But then you hear them and you have no idea what they're talking about. But then you bring on somebody else that perhaps isn't as experienced, but is able to articulate in a way that we can all understand and be able to educate others on the complex subject matters that we tend to cover here on these live streams. And you wonder, would you rather hear from the super intelligent person that you have no idea what they're talking about? Or would you rather hear from the person that perhaps doesn't have the same resume, but is able to really effectively communicate? We are in the communication business. So I try to look for people that can be quite eloquent in articulating how we dissect and analyze and learn about these complex topics. And the hardest one, I will tell you just from experience, is DNA. DNA is the hardest. You talk to most people that live in a research lab and you have no idea what they're talking about. It takes a very rare breed for somebody that works in DNA to be able to, in forensics in general, to be able to really, truly break down for a jury or for the general public at large what on earth they are talking about. Yes, this is still a potential capital case. That's a question from Olivia. We're about to wrap up here momentarily. So it's really a last call for any questions before we wrap up. Maria, why do you think the other two roommates survived? I hope that we learn more to be able to find out why some lives were taken and some were spared. We don't know enough to even really scratch the surface of this question, Maria. We don't. One of the surviving roommates making eye contact with somebody with bushy eyebrows and a certain build and being able to remember and relate that to investigators, but why that surviving roommate is alive today while the others are not, that is something that might become more clear during trial. And I hope that we get answers. This is all about finding truth. Four says why at first locked doors and now there were two hearings today. First one was behind locked doors. The second one was not, and the scheduling conference was not. So we don't know the outcome or the arguments really that were presented in the first hearing today, but they are both of those hearings. Let me just point this out. Both of these hearings, it was nearly a foregone conclusion that both were going to be denied. That it was just the defense procedurally doing what they could to make sure that they are exploring all legal options to get the case, the indictment really that was handed down by the grand jury tossed out. And so while they were considered major long shots, Hail Marys, they had to be considered, and they were ruled on today, and they were ruled on as expected by most legal analysts. One or two more before we wrap up. This and this and this. I don't know what that comment means. Little Patty, I didn't hear the name of the town. Was it Mentor, Idaho? Is that what it was? I don't know. I'm not sure. I have to go back and listen. The audio was good, not great. It was better than expected. But the acoustics in a courtroom and how sound bounces off the walls can be really difficult to sometimes to hear specifics, especially when you're talking about a state. I've never covered Idaho. I mean, outside of, doing this coverage, I'm very honest and upfront about that. I've been a reporter and I've covered directly, I think 8 states: New York, Pennsylvania, Delaware, Virginia, Maryland, a lot of northeastern states. I moved down to the south, Mississippi. I covered some news in Mississippi for a while. Alabama, I was there for a long time. I covered news, sprinkle of news in Georgia, and then now really predominantly Florida. Alexia, it was the University of Idaho president said it was part of the healing process, in essence, to be able to move on. And with that, folks, we're going to get going. It's been a lengthy stream. How long has it been? Almost 3 hours. Really appreciate everybody joining us here today. We got some exciting things in the works as far as our ability to do a lot of live streaming and do it in a way that is forward thinking, because a big part of our mission here in the Stream Center is to include you. The news can include you and your opinions and your questions, and sometimes the best questions come from our audience members, questions that I don't think of. So interactive journalism is my passion. It is how the Stream Center got built. We have a lot more streaming coverage to come on Idaho. Of course, we have the Petito case that is scheduled for May. And we'll be talking, I'm sure that there will be some Murdoch conversations to occur as to whether or not what the legal sort of future is in South Carolina. But really appreciate everybody. You can follow me on social media at WFLAJB. For more details on these cases that I follow. Really important, you can email heyjb@wfla.com if you're trying to reach me. If you're trying to reach the newsroom to provide feedback for our live streams, you can do so by sending it to news@wfla.com. And really, we are here for you. Why do we cover Idaho? Why do we cover Petito? Why do we cover Harmony Montgomery? Why do we cover all of these cases? Alex Murdoch. These are cases that draw immense interest, but we get that interest by hearing from you, our audience. So never be shy as far as communicating. Hey, JB, look into this case. Have you heard about this? Or there's a trial happening you might want to look into in this state or in this region of the country. We do our very best here to try to do as much, and we are going to do more live streaming in 2024 than we've ever done before. That I can assure you. Really appreciate everybody joining us. A special thank you. We'll hit the applause button. A special thank you to our moderators for keeping our comment section kind, respectful, on topic during the actual hearing itself. Especially, you guys know how I feel about you. I appreciate you, and we'll see you next time here from the Stream Center on Hey JB Live. Thanks so much for joining us. We'll see you next time, folks. Have an excellent weekend. Be safe.